should come up with a little notice. So the obligatory notice, obviously we're going to tell you that you're being recorded, but otherwise this doesn't make any sense. But if you're new to the channel, welcome back to the Data Protection Diaries, or welcome to the Data Protection Diaries. If you're not new to the channel, welcome. We are today very, very lucky, and I'm very excited to say that we are joined by Eduardo Ustaran. Eduardo is a partner at Hogan Lovells, and a little bit different from what we normally do. Today we're going to be talking about standard contractual clauses and international data transfers. Normally I'm quite happy to sort of waffle on, but on this occasion it's something I think that requires that little bit more sort of technical insight and technical knowledge, which is why I wanted to get Eduardo on the channel. But Eduardo, I'm going to let you introduce yourself because you'll do a much better job than I do, and then we can take it from there.
Thank you very much. Thanks, Richard. So I'm Eduardo Ustaran. As you say, I'm a partner at Hogan Lovells, normally based in London or traveling around the world. And my role is I co-lead our global privacy and cybersecurity practice. I've been doing this for many years, maybe more than 25 years. And at Hogan Lovells, what we do as a team is we advise on the whole range of very strategic privacy and cybersecurity compliance issues, dealing with crisis, dealing with regulatory investigations, and all the fun stuff that is happening in our little world.
So this sort of international data transfers is really where your clients are going to see some of their biggest challenges of recent times, isn't it? So I think it's worth for people watching that we go sort of not too far back to the beginning, but back to where this all came from. So everybody talks about Schrems II. That tends to be the way this is sort of categorized for people. Can you give us a bit of background to what's been happening and why this is now becoming such an important issue? Sure.
So international transfers of personal data have always been regulated by European data protection law, as you say, going back to the beginnings in the 90s with the directive. But what happened with Schrems was that, if you remember Edward Snowden, which who in 2013, I think it was, revealed all these surveillance activities by the US government, that led to a real change to the approach on international data transfers, because there was a perception that the data that was transferred to countries like the US was potentially unsafe or unprotected, because government agencies like the intelligence services or law enforcement could have free access to the data. Max Schrems, who was a privacy activist, and he was very concerned about this, that led to the original decision that invalidated one of the original mechanisms for international data transfers, the safe harbor. Then the European Commission and the US government agreed the successor to the safe harbor, which was the Privacy Shield, but Max Schrems carried on. And what happened was that the Irish Data Protection Commissioner that was in charge of dealing with that, said, look, we need to let the European Court of Justice decide whether the use of standard contractual clauses, which is the #1 mechanism that the vast majority of organizations across Europe use to send data to their subsidiaries or their affiliates or vendors in other countries, whether these standard contractual clauses are able to protect the data. So in July of this year, the European Court of Justice decided that certainly the Privacy Shield that had replaced Safe Harbor was certainly not good enough, and the standard contractual clauses could only be good enough if one assessed the level of protection that they really provided, and then if you could see that in isolation they didn't properly provide the level of protection that was needed, you had to impose on top of those standard contractual clauses additional protections. And that's where we are right now. We are in the process of understanding and finding out what is the real level of protection that can be afforded when you rely on standard contractual clauses or anything else in order to send data outside the EU and the UK.
So the interesting thing that certainly seems to cross online, and when people are talking about this on LinkedIn, that a lot of people are talking about it in a very US centric viewpoint. So they're saying obviously Schrems II, it's data transfers to the US, but this is a much wider, this is an international problem. So is the Schrems II guidance, or the issue from the EDPB and standard contractual clauses, are they one and the same, or are these two separate things that people need to give consideration to?
So you need to look at it as a whole. And again, the law in a sense hasn't changed for 25 years. The law is that if you are in Europe or the UK and want to transfer data outside or make your personal data accessible outside the EU or the UK, you can only do that if there are adequate safeguards in place, either because the other country at the other end, the local law provides those adequate safeguards, or if not, you put in place those adequate safeguards. So it's a matter of, the way to understand it is European data protection needs to follow the data wherever it is in the world. And what happens is that when the data is around the world, whether it is in the US, because most of the service providers that we all use in this part of the world in Europe are US based, or is anywhere in China or in Australia, wherever it is in the world, it needs to be protected at a European, with a European level of protection. And the challenge that the two Schrems cases have thrown to us is around not so much the level of protection that a service provider gives to the data, but the potential, the risk of the potential access to that data by public authorities, by government agencies. In the context of surveillance, that is obvious that there will be jurisdictions out there where the intelligence services, part of their role is to tap into the data that comes from other jurisdictions, certainly from Europe, and retrieve that data and study it in order to do their job. And the question is, how do you find the balance between that happening, that level of surveillance happening, and you as an exporter of data to that jurisdiction is still protecting the data? That's what it comes down to.
So, and how easy do you think that is going to be for because I mean we're fortunate that for some of us, obviously, or some organisations have access to resources, so they have privacy lawyers, or they have legal teams, or they have data protection support. But for a lot of businesses out there, that level of knowledge is not going to be available within their organisation. So how easy do you think it's going to be for businesses to try and navigate around this? And is there anything that people should be starting to do to try and help them get prepared for 2021 and beyond?
So the thing is, the Schrems II decision has complicated things. That's the reality. So my job, like your job, is to solve these problems, right? And the problem has become more difficult than ever before, because before this decision, the solution was fairly straightforward. The standard contractual clauses provided that level of protection. So to resolve this issue was as simple as entering into an agreement with a service provider or whichever party was at the other end of the ocean, and ensure that agreement had these standard contractual clauses. The decision by the European Court of Justice in Schrems II, what it says is, yes, the standard contractual clauses provide a baseline level, but if you are sending the data to a country where there is greater exposure of government access to data, on top of that baseline, you need to add additional protections. So that's the complication, that we now need to rely not just on the standard contractual clauses, which is easy because the standard contractual clauses are published by the European Commission. They're publicly available. It's free. You just need to Google them. get them, sign them, and that's it. And now on top of that, you're going to have to find some additional clauses or additional protections to do that. So that's the complication. But eventually, I think it will become more standardized. It will become more, the solution will become more consistent. And I think for the medium, small company, essentially using service providers outside the EU, typically in the US, the solution is going to have to come from the service provider, which says, look, we understand the challenge here. We do provide the baseline level, and we do provide the additional level of protection. And that's where I think the solution is. So, in summary, the key thing is to ensure that there is a baseline level of protection, which, for example, the standard contractual clauses will provide. And then on top of that, the exporter of the data has to find a way to add that additional level of protection that will provide a full package. But in reality, for a medium, small enterprise, the way to resolve this problem, I think, is to rely on the service provider. It will be those big service providers that will say, don't worry, your data is safe with us, because we not only provide the level of protection that is in our contract, in our standard contractual clauses, but we apply additional protections. They may be technical measures, they may be additional contractual mechanisms, that the full package is what provides the type of protection that you in Europe need to send the data to us.
It becomes incumbent on the bigger players, essentially, rather than the small businesses to find a way forward.
I think that's likely to become the solution, in my view. We'll see, but I think that seems the obvious way forward.
Because the other challenge that comes up, or that always comes into my head, is obviously these things were in place for, the previous contractual clauses were in place for a long time. Privacy Shield was in place for a long time, and Safe Harbor for a long time before that. And although these things have been challenged and they've been brought down, how easy is it actually going to be to enforce against these things? So the fear is sort of left in the SME, certainly in the small medium businesses, thinking, I need to deal with this. What are we going to do? But then it certainly seems that if it's incumbent on the large corporates to come up with a better way of dealing with this, are we ever going to be able to see any effective enforcement against this, especially as we move? Well, we are now formally leaving the EU as well, so the ICO has even less oversight of what's going on in Europe. Does it become sort of a moot point almost?
Well, I don't think it'll be something ignored by the regulators, the ICO, or any of the European counterparts. I think it's always a matter of priorities. Right now, international data transfers is a top priority and is seen as a risk for European data protection. And therefore, perhaps of the most active data protection authorities in Europe will look at this as an area that they want to prioritize and they want to investigate at least. We'll see whether that an investigation leads to any kind of enforcement action and against whom. But I wouldn't say that just because this has not been a top enforcement priority, then we can relax about it. I think we need to be careful. Not every single unlawful transfer will be subject to some form of enforcement action. So maybe you have to be unlucky to be the one that is caught. But we live in a world where we need to apply a risk-based approach to every single decision, and I think it's important to address this issue to the best of our capacity.
So, in terms of that sort of small business, the key takeaway is push your service providers. Ask them the right questions. If you're find out where your information is going, I suppose, is the first thing. And then if you are concerned about an international transfer, make sure you're talking to your service provider, trying to get, ask them for the right paperwork. And if you're not comfortable, maybe it's time to change service provider. Dare I say it?
I think that is that a solution? I think when those type of decisions are made based on data protection compliance or the lack of it. They tend not to be the right business decisions. I think it's more important to try to find the way to comply with the law rather than to find another way of doing your business that doesn't hit the problem. So I think, look, what it comes down to is, I think it's important that businesses of all sizes understand the challenge and what this is about. And it's simply about the fact that in today's world, cloud computing by definition is global, and therefore we all need to deal with the issue of international data transfers. It's not just the big corporations issue, it's an issue for everybody. Secondly, it is important to understand where your data is going, because if you don't even know where the data is going, then how you're going to know if you have a problem to solve. There is some emphasis perhaps there in terms of what is a very bog standard obligation under the GDPR, which is the Article 30 records of processing, one of those kind of things that is not very sexy, but actually is important because it gives you the picture of where, amongst other things, of where the data goes. So look at your records of processing and then identify, okay, so who are the vendors that are dealing with our data? And then the most logical next step is find out what those vendors are doing in order to protect your data. If they are a cloud service provider, which provides a fantastic service all over the world and back in one continent and customer support in another continent, okay, so they surely will have figured out how to resolve the issue. And I think it's a bit of a, it's not them against us, it's like how do we resolve this issue, because data globalization is not really going to go away. The fact that there are service providers all over the world providing services to us that are useful and probably economical means that we need to try to find a way to overcome the legal challenges.
Yeah, it's very true. It's not like all of a sudden everyone's going to push their data to an EU data center, or everyone's suddenly going to end up in Dublin. It's always going to be there, isn't it? We can't get away from it now. We live in a world where we want to be free. Well, we want information to be free.
The thing is, data localization, which is often seen as, okay, well, so that's the solution. I think we need to be careful. We distinguish between data localization as an economic principle that countries and the European Commission is talking about. Okay, we should have service providers in Europe, and we should develop a cloud industry in Europe. That's all very well, and I think it will be good for Europe and the UK if that were to happen. But that's not related to the protection of personal data. The protection of personal data doesn't only happen in Europe, it needs to happen throughout the world. And therefore, if the services are provided globally, then what we need to do is to again, look at how the protection can follow the data.
Yeah, makes sense. So you're building from your base, and you're working out your risks, and then working out how you can put the controls in place to support it. You make it sound simple, like it's gonna be fine. We've fixed it.
Yeah, we just it's a bit of a team effort, but I think we'll be all right.
The final thing I wanted to touch on is that one of the things that gets bandied about quite a lot as a solution to all of this is binding corporate rules, and everyone, just set yourself up with binding corporate rules if you're following binding corporate rules. Now, in my experience, it's a very complicated, drawn out process that requires a lot of input from regulators across Europe, and it's not something that's easy to do. Is that something that you would ever recommend to an organisation, or is it something that is more focused on your side of the fence, on much larger international businesses? Is it even worth a consideration?
I think it is worth considering binding corporate rules as a principle, as a mechanism. Is not something that you can only do if you have a certain size. Because as a concept, binding corporate rules, all it is some form of internal code of practice that applies European data protection rules across the board. So if any organization can aspire to do that. And if you're a smaller organization, then that may be an easier job than if you're a massive organization. What makes binding corporate rules complicated is that you have to seek and obtain the regulator's approval, express approval. And they make that quite challenging.
Yeah.
And I think the issue over the years has been, how do we get to a point where it is in everyone's interest to adopt binding corporate rules, which provides the best standards of protection globally, but that is achievable because regulators are realistic enough in terms of seeing that as a gain in itself. So I think, I know BCR have been under development for many years, and they continue to develop. But I'm a fan because, unlike standard contractual clauses, which is a sort of it's a picture and it's just that you either do it or you don't, binding corporate rules is meant to be more flexible because you adapt your own internal practices to meet those standards. So I think definitely it's something worth considering, but you need to look at all aspects of this challenge.
So it's more of a cultural change, taking a binding corporate rules approach. It's, you know, much more integrated within the organisation, whereas obviously standard contractual clause, as you say, is a snapshot. You hand it over, you sign it. You know, you're safe as it.
Yeah, but you see, this is what the Schrems II case has revealed or has exposed: the fact that standard contractual clauses shouldn't be seen as just a piece of paper that you sign, put in the drawer, and forget about it. The idea behind standard contractual clauses is not too different from binding corporate rules, because the obligations that you need to comply with, whether you do standard contractual clauses or BCR, the obligations are the same. The principles in the GDPR and the accountability obligations in the GDPR. So whether you put the wrapper of SEC or the wrapper of BCR is nowhere here nor there. The question is what you do in terms of data protection compliance.
Okay. Yeah, I like that. It makes it easier to digest when you look at it that way. It's, you know, I think it becomes very easy for people to see it as a tick box exercise, and you know, and obviously it's not. There's a lot that still needs to be considered and done in the background. Even if you are going to rely on these things within your contracts, you still need to go out. You still need to be investigating or checking your suppliers, doing your own due diligence. You know, it's one part of a much bigger framework. Perfect. Well, I think for me, that's been absolutely fascinating. It's been really good to have you on. I really appreciate you taking the time to talk to us, because I know you're extremely busy. If you're not following Eduardo on LinkedIn, please make sure you do, and we'll put your details and Hogan Lovells details down in the description below as well. But thank you very much for joining us. If you've enjoyed watching this, please do subscribe to the channel as well. Leave any comments or thoughts down below. And if there's somebody else that you think that would be good for us to talk to in this series, let us know. But for now, I'd like to thank Eduardo for joining us. That's fascinating, and we look forward to seeing you again.
A pleasure to chat with you. No problem.
Take care.
All the best.
Bye-bye.